I'm delighted to be here again on another episode of your enlightening family law conversation show, The Late Night Intercourse with Chioma. As usual, I am Chioma Onyenucheya Uko, your host, also known as the Zest family lawyer. So, we're going to do something. We're going to switch up things a bit in this episode. In the course of the past episodes, we've gotten quite some questions from people who send me questions to say, hey, I had this experience or that experience, or in a situation such as this or that, what should I do? So I decided that the better thing to do tonight will be to just take some of those questions and attempt answers to them. So, and tonight, I'll be taking questions that revolve around the subject of divorce. That's what I'll be taking tonight. And I'd like to read some of those questions and then respond to them. So I'm sure that you may learn a thing or two from the responses I'll give to some of these questions. So let's take it off. This person says that her spouse just asked for a divorce. What should she do? That's the question. And well, of course, it's not the best of times for anyone when the spouse, comes up to say, hey, it's over, I want out. And chances are that one may lose equilibrium, for some time. But the most appropriate thing to do once your spouse says he or she is no longer interested and asking for a divorce will be for you to consult a family lawyer. That is the first thing to do. Now, in consulting a family lawyer, it is possible that though your spouse have said he or she is no longer interested or wants out, it is possible that you may get counsel that may help you resolve whatever the issues are and you're able to save your marriage. Very possible. It's possible that both of you, from the counsel you get, will get opportunity to maybe a mediation or some sort of, mediated settlement that enables both of you resolve your differences and, attempt another chance at making your marriage work. Where that fails or where that possibility doesn't succeed, the next thing would be for your counsel to advise you on the options available to you so that you respond or act from an informed position. If you allow emotions to guide you, you may say things you shouldn't say, you may do things you shouldn't do, you may take steps you shouldn't take. So, but with a counsel, particularly if you're talking to a family lawyer, he or she will be able to put you through advising you on the provisions of the law, on the elements to prove the ground of a divorce, on whatever defense you may have to possible allegations from your spouse, on the things you can ask for and the parameters, on which you can ask for those things, and generally just advise you. So I think that more than talking back or throwing tantrums or throwing insults, or generally just taking brash steps, the better thing to do if your spouse asks for a divorce will be to quickly consult a family lawyer. And the counsel of the family lawyer can help you either resolve whatever the differences are or help you through the process with as minimal damage as is possible, ensuring that your best interest is protected. So that's my answer to that question. We'll take another one. Okay, someone says, I got a call from someone who said he has a divorce petition he wants to serve on me. I refused to continue that conversation because I am afraid that if I tell him where I am or that if I receive the petition, I may have made a mistake. What should I do? Okay, so I guess essentially what this person is talking about is whether he or she should take service of a divorce petition that has been filed against him or her. And I think the best thing to do, yes, is to take service of the petition. And I'll tell you why I say that. In the event that your spouse has filed a petition for divorce, if you do not take service of the petition, how will you know the contents of the petition? How will you be able to plan an answer? How will you plan a defense? How will you be able to respond to that petition? You won't be able to do that. In any case, though the law expects that the process should be served on you directly as a primary means of service, that is not the only means by which you can be served the petition. The law allows for the petitioner to serve that petition or for anybody to serve a process on another person through secondary means. There are alternative means permitted by law. So what it means is that the petitioner or anybody else who is trying to serve you a process, whether in a divorce or in any other legal matter, in any other court proceedings, and you frustrate the service of that process, or you evade service, or you make it difficult or impossible for that person to serve you, the person can take an application to court and ask for leave to serve you that process by substituted means. So if he obtains an order of court that permits him to serve you that process by substituted means, your evading that service would not have amounted to much. Yes, you may have bought little time, but it may also be little time that is injurious to your best interest. So what it means is that if you refuse to accept the process and they obtain an order of court for substituted service on you, they can actually serve you that process by maybe sending it to you through an electronic means like maybe WhatsApp, message, or email, SMS, or any of those. They may serve you that process through, publishing it in a national daily or any other medium, any other news media, whether it is online or offline. They may also serve it on you through sending it by courier. So they may actually DHL it to you and then you receive it inadvertently, not realizing that the content of what you have received is a court summons or a court proceedings, court process. So there are many means by which you can be served. They can also paste it at your place of abode or any address of yours that they know. They may also publish it. Okay, I've already spoken about publishing it in a national daily. So what it means is that if you don't accept service and you allow them explore any of these other options, it may be an option that doesn't serve your best interest. So for example, they now paste it at your address or paste it in a public place like a court premises. Everybody gets to read it before you read it. And the content may be such that you don't want the public reading it, you don't want it in the public domain. So accepting service is better for you because it equips you with what you can consult a lawyer with and helps you in preparing, a strong answer or a strong defense to the petition that have been filed against you. So I think that anytime a court process has been filed against you and you are about to be served, the best thing to do is to receive service. If you're unable to receive service, you may direct that service to your lawyer, particularly where you have already briefed a lawyer in that case. Once you have briefed a lawyer and authorized the lawyer to act on your behalf, that lawyer can also receive the process from you. So, like I've said, the important thing to do is to accept service. That's my advice on that. Thank you. So the next question here is, I am tired of my marriage and I want to file for a divorce. Someone told me that I have to file the divorce in a court in the state where we got married. Unfortunately, we no longer live in the state where we got married. What do I do? Where can I file the divorce? Okay, the answer for that is simple. Under the Matrimonial Causes Act, being the law regulating matrimonial matters, including divorce and the rest of them, you can file the petition for a divorce or any petition bordering on any matrimonial causes. You can file it in any court in any part of Nigeria. Unlike what obtains in other civil matters where you have to file, a court proceeding in the jurisdiction where the cause of action arose. In the matrimonial cause, no, you don't have to do that. You can file it in any court in Nigeria. So what that means is that, assuming the person who asked this question got married in Abia State and presently lives in Taraba State and wants to file a petition for divorce, he or she does not have to wait until they can go to Abia State where the marriage was contracted before they can file for a divorce petition. They can actually file for a divorce petition in any part of Nigeria, including where they currently live, or where either of them currently live, or where either of them frequently visits and finds most accessible. So it must not happen in the state or in the jurisdiction where the marriage was contracted. It can be filed in any part of Nigeria. So I think that answers that question, and I'll be happy to throw more clarifications if I see further questions on the subject. And then for this evening, the last question I would like to take is, okay, there are quite some questions here, I tell you, so I'll take the much I can, and then in another episode we'll continue if we have to. So here it says, what is the difference between a marriage annulment and a dissolution of marriage? Please explain. Okay, I don't know why that person wants that answer, but of course I'm glad to answer. An annulment happens where a marriage was void from the point it was entered into. So for a marriage to be valid, that marriage, like I had treated in one of our past episodes, has to be a marriage between people who are no longer minors, between adults, consenting adults. So the marriage must happen between adults. They must be persons who entered into the marriage union consensually. So it must be a freely given consent. It must be a voluntary consent. It must be a consent that is given with full knowledge and awareness of the circumstances and situation of the union. So consent must be obtained must be given by both parties. Then the parties must be persons who are not bound by any degree, relationship, either blood or other relationship like marriage or their siblings and things like that. And it must also be that the marriage happened in a licensed place where marriages can happen, which could include maybe a church that has been so licensed or at the marriage registry. So those are some of the qualifiers for a marriage to be valid. Now, if a marriage happens and that marriage is not valid, for example, a brother marries a sister, or yes, another point I didn't make is, both persons must be persons who are single and who are eligible to marry. So if, for example, a marriage happens between siblings, or a marriage happens between a man or a woman who is already married to another person, and then the person comes to marry another person under the act, it means that from the onset, that marriage is void. It is not a proper marriage. So if that becomes the case, the law says that instead of a dissolution, which we call a divorce, the pronouncement the court will make will be an annulment. The court will make a decree of annulment saying that this marriage was not even properly a marriage, so it stands annulled. Instead of a case where a marriage is actually valid, and then because of any of the conditions which the court expects to be proven to show that a marriage has broken down irretrievably, the court realizes or comes to the decision that that marriage needs to be dissolved. So the difference between an annulment and a dissolution is that in an annulment, the marriage itself was invalid. It was void at the time it was contracted. But in a dissolution, the marriage was valid until maybe developments made either of the parties or both parties to want the marriage dissolved. So that is the difference. I hope that is clear. And I think it will be best that we wrap it up here and then continue with further questions and answers in another episode. And hopefully then I'll be able to also respond to your own question if you will drop it in the comment section. Like I said, I'll be glad to answer any question that borders on any subject, any topic within the family law spectrum. Freely ask your questions, make your comments, and then I would like to react to them at a future episode. And then please subscribe and also click the like button. You can also send us email or follow us on any of our other social media platforms as displayed below or in the email address also displayed below. It's been a pleasant time answering some of your questions, and I'm looking forward to many more episodes with you. Thank you very much for joining me tonight. And it is me, Chioma Onyenuche Uku, the Zest family lawyer, here saying thank you for tonight and see you at the next episode of the Late Night Intercourse with Chioma. Good night.